On December 26, 2018, the ATF reversed its position on bump stocks that it held since 2008. This action set in motion a multi-year legal battle between GOA, other gun rights groups, and the ATF, culminating finally in a recent Supreme Court decision. And guess what? The ATF lost. And so today, we're going to look at this saga spanning 7 years, with 6 of those spent in litigation. Hey, I'm Phil, and you're watching Law and Ammo. But before we get started, I want to take a second to invite all of you to GOA's first convention, Goals, the Gun Owners Advocacy and Leadership Summit in Knoxville, Tennessee, on August 17th through 18th. Experience tons of booths from your favorite manufacturers and hear from the top voices in the Second Amendment community. And the best part, it's free for GOA members. And so register now with the link in the description, and I'll see you in Knoxville. All right, back to the bump stocks. In 2017, a mass shooting occurred in Las Vegas during the Route 91 Harvest Music Festival. The tragedy prompted calls for gun control, and the Trump administration responded by blaming the Obama-era ATF for allowing bump stocks in the first place, then directing his ATF to ban them. And ATF complied and got to work on their rule. But there were a few problems. First, since 2008, ATF had claimed that bump stocks didn't convert semi-automatic firearms into machine guns. Second, executive agencies can't create law. A bump stock is a firearm part, falling outside of the purview of the Gun Control Act and the National Firearms Act. ATF would have to make some serious changes to regulate bump stocks, and that's exactly what they did. On March 29, 2018, ATF posted their proposed rule to the Federal Register, reversing their long-held position on bump stocks. ATF received hundreds of thousands of comments on the rule, many from GOA members. Unfortunately, that didn't stop them, and on December 26, 2018, while many Americans were on holidays celebrating Christmas, the ATF released their final rule on bump stocks to the public, with an effective date of March 26, 2019. In the final rule, ATF changed the definition of a machine gun to include bump stocks. ATF also changed the statutory definition of a single function of the trigger and automatically. Gun owners of America knew what the consequences of this action could be. And suddenly, a ban on all semi-automatic rifles became possible through this kind of administrative rulemaking. If a bump stock is a machine gun, all semi-automatic rifles are machine guns. And not only that, but the ATF had turned hundreds of thousands of law-abiding gun owners into felons overnight with the stroke of a pen. So, on the same day that the ATF released their final rule, we filed our lawsuit against the ATF. We filed our lawsuit in the Western District of Michigan, which is in the 6th Circuit. Joining us in the lawsuit were the Virginia Citizens Defense League and Tim from Military Arms Channel as a plaintiff in that suit, along with a few others. We argued our case at the federal courthouse in Kalamazoo, Michigan. We were assigned Judge Paul Lewis Maloney, a George W. Bush appointee. In our lawsuit, we argued that the ATF had exceeded their statutory authority by creating this rule, as the rule was politically motivated and the ATF has no power to create law, as that's the job of Congress. You'd think that would be a no-brainer. Government agencies often overreach, and then the courts or Congress has to set them straight, but this time it wasn't so simple. Much of the discussion in court centered around the ATF's defense of their actions, a legal doctrine called Chevron deference. So what is Chevron deference? Well, Chevron deference is a legal doctrine that allows judges to defer to the opinion of experts, like administrative or regulatory agencies. Because judges aren't experts on all subjects, this is often the way the cases are decided, through deference to expertise. Thanks to Chevron deference, the law can mean whatever the current administration decides it should mean. And in this case, it meant that bump stocks were machine guns. That's bad, especially in our case. ATF created this rule, then argues that they're the experts, and because of that, the rule is legal because they said so. And that's why our case should be dismissed. And this isn't just a problem for us. Chevron remains one of the most cited legal doctrines in the United States administrative law. Experts estimate it has been cited in thousands of cases since the case Chevron USA Inc. v. Natural Resources Defense Council was decided in 1984. There's currently a massive Supreme Court case about the Chevron deference called Looper Bright Enterprises v. Raimondo. We cover that on an episode of One in the Chamber. GOA filed a brief in that case, and we expect the Supreme Court to have a ruling on that any day. And if you're interested in learning more, we'll leave a link to that video in the description. So, thanks to Chevron, our lawyers had to work to argue against the ATF's unconstitutional overreach while also debating the judge on the ATF's qualification for judicial deference. Well, the judge felt that the ATF knew better. He granted them deference and ruled against us. We then appealed to the Sixth Circuit. At the Sixth Circuit, we were assigned a panel of 3 judges: Alice M. Batchelder, a George H.W. Bush appointee; Eric E. Murphy, a Trump appointee; and Helena White, a George W. Bush appointee. This time, the judges agreed with our argument, overturning the lower court's ruling. In response, ATF petitioned for an en banc hearing. An en banc hearing means on the bench. It's a proceeding where all of the judges of a particular court hear the case. In this instance, 16 judges from the Sixth Circuit heard our case on October 20th, 2021. The panel consisted of 5 Trump-appointed judges, 5 Bush-appointed judges, 3 Clinton-appointed judges, 2 Obama-appointed judges, and 1 George H.W. Bush-appointed judge. Here's how they ruled. Ruling against us were 3 George W. Bush-appointed judges, 3 Clinton-appointed judges, and 2 Obama-appointed judges. Ruling in support of us were all 5 Trump-appointed judges, 2 George W. Bush-appointed judges, and a single George H.W. Bush-appointed judge. That's a tied 8-8 ruling, and because of this, the 3-judge panel's ruling was vacated and reverted to the district court's ruling, where the judge sided with the ATF. And because of this, we were left with really only one option: appeal to the Supreme Court. And that's exactly what we did. On March 3rd, 2022, we filed a petition for writ of certiorari. Our case had a ton of support. We received supportive filings from 22 states, the New Civil Liberties Alliance, the Cato Institute, the NRA, and the Firearms Policy Coalition. But unfortunately, that wasn't enough. And on October 3rd, 2022, the Supreme Court declined to hear our case. But it wasn't all lost there. In Texas, a very similar situation had taken place. On March 25th, 2019, one day before the ATF's bump stock ban went into effect, local gun shop owner and Texas radio host Michael Cargill surrendered his bump stocks to the ATF under protest. And later that same day, he filed a lawsuit against the ATF. Cargill filed suit in the Western District of Texas, as he lives in Austin. This is in the Fifth Circuit. Cargill was assigned Judge David Allen Ezra, a Reagan appointee. Judge Ezra ruled in favor of the ATF, and in response, Cargill appealed to the Fifth Circuit. At the circuit level, Cargill was assigned a panel of 3 judges: Stephen A. Higginson, an Obama appointee; Greg Costa, another Obama appointee; and James L. Dennis, a Clinton appointee. Of course, these judges sided with the ATF in a unanimous decision, and so Cargill then appealed to an en banc hearing where he won in a 13-3 decision. And I guess we know exactly who those 3 judges were.
Finally made it to court at the federal court and had a trial there, which was actually a pretty funny proceeding, because what happened was the judge in that case kind of compared the bump stock to a shotgun. And so he said, so you mean to tell me every time I pull with my left hand like a shotgun, so that's what we're talking about, and that's a machine gun? It's like, no, a shotgun is not a machine gun. So complete chaos. So of course we lost that case because he wasn't educated about firearms. And then we appealed that case to the Fifth Circuit. And in the Fifth Circuit, it's mostly conservatives, appointed judges, but I think there are like 3, maybe 4 or 5 Democrat-appointed judges. So we went to that court. Guess what was the makeup of our 3-judge panel? How many appointed Democrat versus appointed conservative justices you think we pulled out of the 3?
It was 3-zip, wasn't it?
So we pulled 3 Democrat-appointed justices. So of course we lost that case.
Right.
And the way they wrote up their ruling is they kind of agreed that the ATF couldn't create or write law, but they still, sided against us. So we didn't appeal that. That case was picked up again by the Fifth Circuit in en banc. And so we heard that case back in September 2013. I'm sorry, September 13, 2022. And it turned out 13-3 in our favor. Back when they said, hey, let's consider banning bump stocks, there are organizations out there that are Second Amendment organizations that said, okay, well, we'll go ahead and give up the bump stock. But what they didn't realize, if you give the ATF an inch, they're going to take a mile, and you can't do that. You have to have the Gun Owners of America stance of no compromise. That's the only way you have to stop them.
Meanwhile, other cases were set in motion as well. Appellate v. Barr in the 10th Circuit and Guedes v. the ATF in the D.C. Circuit, filed by the New Civil Liberties Alliance and Firearms Policy Coalition, respectively. Both cases were decided in favor of the ATF, thanks to that pesky Chevron deference. But back in the Fifth Circuit, ATF just couldn't let Cargill's win stand. The Department of Justice appealed the case to the Supreme Court. The Supreme Court realized that 4 courts had ruled differently. They decided it was finally time to take up the case, with the goal of clearing up the circuit court split created by the other cases and Cargill's case. So finally, on November 3rd, 2023, the High Court agreed to hear Cargill v. Garland. GOA filed an amicus brief in support, and oral arguments were set for February 28th, 2024, nearly 5 years after the ATF's bump stock rule took effect.
To fire a rifle fitted with a bump stock, the shooter simply places his trigger finger on the built-in finger ledge and uses his other hand to press the front of the rifle forward. As long as the shooter maintains that steady forward pressure, the rifle will fire continuously until it runs out of bullets. And it will empty a 100-round magazine, like the ones used in the Las Vegas shooting, in about 10 seconds. Those weapons do exactly what Congress meant to prohibit when it enacted the prohibition on machine guns, and those weapons are machine guns because they satisfy both disputed parts of the statutory definition. First, a rifle with a bump stock fires more than one shot by a single function of the trigger. In common usage today, as in 1934, a function of the trigger happens when some act by the shooter, usually a pull, starts a firing sequence.
Notice how the government ignores the fact that a bump stock equipped rifle is still semi-automatic, instead saying that a gun is full auto now because it is. Now compare that with the counter-argument from John Mitchell of the New Civil Liberties Alliance, who were representing Michael Cargill.
The statutory definition of machine gun extends only to weapons that fire more than one shot automatically by a single function of the trigger. Mr. Cargill's non-mechanical bump stocks fall outside the statutory definition for 2 separate and independent reasons. First, a bump stock-equipped rifle can fire only one shot per function of the trigger because the trigger must reset after every shot and must function again before another shot can be fired. The trigger is the device that initiates the firing of the weapon, and the function of the trigger is what that triggering device must do to cause the weapon to fire. The phrase function of the trigger can refer only to the trigger's function. It has nothing to do with the shooter or what the shooter does to the trigger, because the shooter does not have a function. The statute is concerned only with what the trigger does and whether a single function of that trigger produces more than one shot. Second, a bump stock-equipped rifle does not and cannot fire more than one shot automatically by a single function of the trigger, because the shooter, in addition to causing the trigger to function, must also undertake additional manual actions to ensure a successful round of bump firing. Everything about the bump firing process is manual, and there is no automating device such as a spring or a motor in any of Mr. Cargill's non-mechanical bump stocks. The process depends entirely on human effort and exertion, as the shooter must continually and repeatedly thrust the forestock of the rifle forward with his non-shooting hand, while simultaneously maintaining backward pressure on the weapon with his shooting hand. None of these acts are automated, and the Solicitor General has yet to identify any component of Mr. Cargill's devices that automatically performs any task that is necessary for bump firing. The statute is unambiguous as applied to Mr. Cargill's non-mechanical bump stocks, and we ask the Court to affirm on that ground.
behind the government's argument is the sense that this statute was initially enacted because of what some of the individuals did during Prohibition. And there was significant damage from machine guns, carnage, people dying, etc. And behind this is the notion that the bump stock does the exact same thing. So with that background, why shouldn't we look at a broader definition of function, one suggested by the government, as opposed to just the narrow function that you suggest?
The problem with the government's argument, Justice Thomas, is that the phrase single function of the trigger can only be construed grammatically to focus on the trigger's function and not on what the shooter does to the trigger. And that's so for many reasons. For one thing, there cannot be a subject of function because a shooter does not function a trigger. Only a trigger can have a function and not a shooter. Now, the Solicitor General is trying to replace the word function in the statute with the word pull. And if the statute had actually said a single pull of the trigger, that phrase would clearly refer to an act taken by the shooter, because only a shooter can pull the trigger. The trigger certainly can't pull itself. So if the court is going to interpret the statute based on what it says, rather than based on the purposes or perhaps the overarching goals of what the 1934 legislature might have been, there's no way it could accept the government's construction of the statute because it is changing the enacted words.
Mitchell is right. The ATF was attempting to rewrite the law for their own purposes. Thankfully, the Supreme Court agreed with Cargill in a 6-3 ruling, holding that the ATF exceeded its statutory authority by issuing a rule that classifies a bump stock as a machine gun. The opinion written by Clarence Thomas states that, moreover, ATF's position is logically inconsistent because its reasoning would also mean that a semi-automatic rifle without a bump stock is capable of firing more than one shot by a single function of the trigger. Yet, ATF agrees that this isn't the case. ATF's argument is thus at odds with itself. This argument should sound familiar to gun owners. Interestingly, the decision is filled with detailed diagrams showcasing how machine guns and semi-automatic triggers work. In the dissent, Sotomayor compared bump stocks to ducks, saying, "When I see a bird that walks like a duck, swims like a duck, and quacks like a duck, I call that bird a duck. A bump stock-equipped semi-automatic rifle fires automatically more than one shot by a single function of the trigger." Sotomayor's dissent clearly disregards the statutory definition of a machine gun and how these devices operate. Again, by Sotomayor's own logic, all semi-automatic firearms are machine guns. This is why it's important to appoint pro-gun judges. Imagine if the Supreme Court were filled with Sotomayors. What a disaster that would be for the Second Amendment. Of course, in response to the decision, the corporate media exploded. So too did the billionaire-funded anti-gun lobby, their allies in Congress, and the White House.
Today we got confirmation that the Supreme Court is fully in the pocket of the far right. In fact, they're even further to the right than former President Donald Trump.
The device that allows a semi-automatic rifle to fire hundreds of rounds per minute.
People have waited long enough for real action. The president has said he will sign a bill. It's time to act.
The Supreme Court has never been as out of kilter as it is today. The fact of the matter is that this has never been a court that's been this far out of step.
Even the ATF released a statement from Director Dettelbach, which read, "As the 2017 massacre of nearly 60 people at a concert in Las Vegas makes clear, weapons equipped with bump stocks pose an unacceptable level of risk to public safety. In light of today's decision, the President has called on Congress to take action on bump stocks. The ATF stands ready to work with Congress to ensure that these devices no longer cause a threat to American law enforcement and the people they protect." Alito seemingly addressed this sentiment in his concurrence, stating that only Congress has the power to ban machine guns, and they can choose to act. Well, we at GOA have a message for Congress if they even think about it. Neither the ATF nor Congress have the power to ban bump stocks under the Second Amendment, and we will fight tooth and nail to prevent any legislation that restricts access to bump stocks or similar devices. So there you have it, a fight spanning 7 years from 2017 with the Trump administration's announcement to 2024 with the Supreme Court's decision. Bump stocks are once again perfectly legal, and the anti-gun lobby's plan to ban all semi-automatic rifles has hit another major roadblock. GOA will never stop fighting for your rights. I'm Phil, thanks for watching.